Hello everyone, this is Undiga, the Niger fertility lawyer. Today, I'd like to talk about the complexities and the additional demands of international surrogacy, which is something that a lot of people do not completely understand or tend to underestimate. In an international surrogacy, the intending parent or the intending parents leave their country of residence and go to another country for their fertility treatment. And in this case, it's a surrogacy. And so one of the first questions they need to be asking themselves about is, what are the requirements I need to satisfy in my home country to be able to bring a surrogate born child back home? There's always a list of requirements, evidential requirements. They might be genetic requirements, legal requirements, nationality requirements, immigration requirements, domicile requirements. There are different kinds of requirements that are imposed by the destination country as a condition for being able to bring a surrogate born child abroad back into the country. And you have to pay very close attention to those requirements. Now, more often than not, those requirements will need to be met with the use of documents and evidence that is produced from the treatment country. And so it's important to understand that international surrogacy is really a very sophisticated game of show and tell. The destination country says, we have this requirement, and now it is your job to demonstrate through the use of evidence and documents and other procedures that you actually meet the criteria for either to sponsor a child through the citizenship route or through a visa to be able to take that child back to the country where you live. These documents come from a number of different places. I would say in general that the documents come from about at least 7 different sources. The first source of the documents, some of the documents come from the fertility clinics themselves, the fertility clinics that are involved in the fertility treatment. And if there's more than one fertility clinic involved, we would need documentation from all of them. So for instance, if you created your embryos in one country and you ship them to a different country for the treatment, we'll need documentation from the 2 fertility clinics involved, and also the company that was involved in transporting the embryos or the gametes from one country to the other. The next source of the documents comes from the intending parents themselves, because the intending parents will have to satisfy a lot of different requirements, and they will need to provide documents to prove that they meet those criteria. If there's any surrogacy agency involved managing the process on the behalf of the intending parents, we'd also need a lot of documentation from them, because some of the requirements will need to be satisfied with documents that are produced by the surrogacy agent or the surrogacy manager, which in some cases might even be the fertility clinic themselves. There's also a lot of important documentation that comes from the surrogate herself. Some of those documents will be collected from the surrogate before the birth, and some of those documents will have to be collected after the birth has taken place, and very often after a certain time period has elapsed, especially when it comes to UK law. Some of the documents will also need to come from the lawyers involved in the treatment. So if there was a lawyer who was advising the intending parents in the treatment country, there will be some documentation that will be required from that lawyer that would help to tie all the documents together when an application to be remove that child from the country needs to be filed. There might also be sources of documents that will need to be gotten from the government, official documents from the government of the treatment country. So if the treatment country, for instance, is in Nigeria, you would need a birth certificate. You would also need any court orders that will be necessary that you may have needed to get over that child to enable you acquire the legal right to remove that child from the country. There might also be legal documents that are attested to by the surrogate herself that come from official sources. For instance, they might need to come from the Ministry the Ministry of Women Affairs, or might need to come from a court where she had needed to attest to an affidavit that will be needed to support the application. Sometimes there are more than one set of lawyers. There might be two sets of lawyers. There may be one set of lawyers in the treatment country and another set of lawyers in the destination country. And these lawyers will be asked to provide documentation in support of the exit strategy that will be implemented to take the child out of the country. If there was a gamete donation involved, for instance, if donor egg or donor sperm was used in the treatment, it will be necessary to show that such donor gametes were used and where they came from. So whoever provided the gametes will also need to provide documentation to say, this is the source of the donor eggs and this is the source of the donor sperm. Now, there may be other documents that are required, and in my practice, this is not an exhaustive list of all of the source of where all the documents may come from. Sometimes there might be more sources of documents. For instance, if there is the movement of gametes from one place to the other, if the number of nationalities involved is more, there will be more documentation. So for instance, if the intending father comes from a different country from the intending mother, and of course the surrogate comes from a different country, or the egg donor or sperm donor comes from a different country, with every additional layer of complexity, there will be an increased number of documentation that will be required, because all these documents put together need to tell a complete story of how this surrogate born child was brought into existence. And all these documents put together in a file, what we call in my practice the Okamara International Surrogacy file. All these documents are put together in a file which are supposed to be used to help the intending parents remove the child from Nigeria and take the child back home to their country, and also to satisfy any other legal or administrative processes that they may need to complete in their home country to be able to become the legal parents of the child. And so because of the number and the complexity of the documents, it's very important to get the legal advice and the services of an experienced fertility lawyer who is very comfortable or who is experienced and knowledgeable about international surrogacy. Because even though the documents are gathered in one country, the documents need to be prepared and reviewed with an eye out for the requirements of the destination country. And that's where the complexity comes from, because the documents will be produced in Nigeria, for instance, if Nigeria is a treatment country, but they will need to meet the requirements of the destination country. And in many cases, in my practice, the destination country will be the UK. So I would be reviewing the documents that we're producing and collating in Nigeria, but not with an eye out only on Nigerian law, but with the process is completely informed and driven by the requirements, the evidentiary and other requirements of UK law. And so because of these reasons, it's always a very good idea to get legal advice early before you even start, and also to engage the services of somebody who knows their way around international surrogacy, which will help you to navigate the process and make sure that you avoid any delays to be able to get your child out of the treatment country and back home. I hope this video has been of value to you. Take care out there.